Good morning and welcome to the October 5th, no, this is not right. November 5th. November 5th. My birthday is in 12 days. I should know this. November 5th, 2025 meeting of the Texas Commission on Environmental Quality. The time is 9:34 a.m. I'm joined by my colleagues, Commissioners Katarina Gonzalez and Tanya Miller, my General Counsel, our General Counsel, Mary Smith, and our Public Interest Counsel, Garrett Arthur. For each item, the argument and discussion is allowed. We'll inform the parties and the public of time limits for their discussion. Registration closed at 9:30, but if you'd like to address the commission on a particular item, and if you're here in person, visit our registration desk or email agenda@tceq.texas.gov with your name, affiliation, and the item you'd like to speak on, and we will do our best to accommodate. For those making presentations, please wait to begin your presentation until I've asked you to begin speaking. And please, please, please make sure that your line is unmuted before proceeding. All right, Mary, let's call the first item.
Okay, item number one is the old business. Item number one is consideration of the application by Formosa Plastics Corporation, Texas, for multiple amended air quality permits. The parties were informed that they would each be allowed 5 minutes of oral argument. The order of presentation will be San Antonio Bay Estuarine Waterkeeper, Formosa, ED, and then OPIC. Waterkeeper may reserve time for rebuttal as it must meet the requirement to demonstrate effectiveness. And with that, we'll begin with our hearing requester.
Good morning.
Good morning.
Is the mic working, and am I ready to go? Excellent. Good morning, commissioners. I'm Gabriel Clark Leach from the Environmental Integrity Project. I'm here appearing on behalf of San Antonio Bay Estuarine Waterkeeper. I'd like to reserve 1 minute for rebuttal. So parties in this matter have argued at length in abstract terms about what kinds of interests and injuries are good enough to make someone an affected person. Those abstract considerations may be decisive where harm or exposure to pollution is a matter of some conjecture, but this isn't one of those cases. I want to share something concrete from Waterkeeper's 2025 hearing request. During the Cox Creek cleanup events, Ms. Wilson estimates she was within 30 feet from the flares when they were combusting gases. She has been so close to those active flares that the noise drowned out all conversation with her peers and all sounds from the local wildlife and surrounding waters. And the heat felt like a furnace. Additionally, the smell from the active flares was sickening, giving her such nausea she felt close to vomiting. Even if Formosa's pollution had not made Ms. Wilson sick, this account shows that industrial flares like the ones Formosa proposes to build diminish Ms. Wilson's personal use of public lands while recreating and while monitoring Formosa's activities under her consent decree, just as much as the discharge pipe interfered with the recreational interests of boaters and fishermen. This commission deemed affected persons in the Port of Corpus Christi matter cited in our brief. But Formosa's pollution did make Ms. Wilson sick. So Formosa says it doesn't matter because Ms. Wilson didn't provide her exact coordinates and because her account of feeling ill while being exposed to pollution is merely, quote, a layperson fact opinion, unquote, that doesn't mean anything unless a paid expert like Dr. Fraser vouches for it. This is wrong, and not just as a legal claim. Ms. Wilson's account is credible, and you should accept it at face value. This commission has historically relied on exactly this kind of account made by Texans describing their experiences to grant affected person status under its rules. Ms. Wilson has been visiting the area immediately adjacent to Formosa between 1 and 3 times a week since at least 2016, and she'll continue to do so in the future. Her personal, repeated exposure to air pollution from Formosa during these visits and its consequences establish that Ms. Wilson has a personal, justiciable interest in the outcome of this matter, one that is distinguishable from the general public, which is the definition of an affected person. But Formosa says no one's an affected person in this matter for its request to significantly increase emissions, because it modeled compliance with applicable standards, and because its toxicologist says this modeling means there will be no discernible impact on any member of the public. At bottom, this is Formosa's core claim, because PSD applicants must demonstrate compliance, must model compliance with air quality standards. No one can ever be an affected person. This is an absurd result. Indeed, Formosa was required to make this same demonstration in order to operate its existing flares. But whatever the modeling of those flares predicted, actual emissions actually resulted in concrete impacts to Ms. Wilson. If flare emissions prior to the proposed increase made Ms. Wilson sick, and she will be exposed to pollution from Formosa's flares in the future, she has a concrete personal interest in testing the sufficiency
That's 4 minutes.
of Formosa's application to increase flare emissions at a contested case hearing. She is an affected person. Thank you.
Thank you very much.
And we'll hear from the applicant next from Formosa.
I believe the mic is still on. Good morning, Commissioners and General Counsel. For the record, my name is Lisa Dyer. I am with the law firm of Beveridge and Diamond, represent Formosa Plastics Corporation, Texas. Thank you for your review of the materials and the details in this robust record. I won't try to capture all of them, but hit the highlights. The application is protective and meets conservative health and welfare standards. This matter is a set of air permit applications. It is not a water quality permit, legislation, rulemaking, an enforcement matter, or a citizen suit. The waterkeeper mistakenly treats the application and the affected person determination under state law as some combination of all the above. The scope of Formosa's application is limited to new and modified facilities. The existing authorized facilities at the complex are outside the scope of the application before you. The ED's review of the application was comprehensive, as I'm sure you'll hear more about that. The application meets all applicable air quality technical and legal requirements. It satisfies BACT, and it is protective. The records show that impacts of proposed emissions will be minimal. Without exception, maximum model concentrations proposed in the application are below all applicable NACs and ESLs. In her health and welfare effects evaluation, toxicologist Dr. Lucy Fraser examined the air quality analysis and determined that potential impacts of the air emissions from the project are expected to be indiscernible for members of the general public, including Ms. Wilson. Record evidence shows that maximum concentrations of proposed emissions from the application are not likely to impact the health, safety, or property of Ms. Wilson or any member of the public who owns property, resides, or who visits areas near the complex. Diane Wilson is not an affected person. Waterkeeper did not identify a legally protected interest personal to Ms. Wilson, as is required by TCQ's definition of affected person. Generalized, unsupported claims of recreational interest in public water bodies and voluntary wastewater and stormwater outfall monitoring are available to any member of the public, no different from Ms. Wilson. Waterkeeper's unsupported recreational and volunteer monitoring assertions do not establish a personal justiciable interest. Ms. Wilson's property where she resides is more than 20 miles away from the nearest project facility in the application. Nothing in the 2019 water quality consent decree, which is wholly unrelated to this air permit application and air quality, establishes a legal right for Ms. Wilson in this application. In the 15th Court of Appeals decision earlier this year, in TCQ versus Waterkeeper, the court evaluated the same asserted interests and very similar facts to those raised here, including a protective air quality analysis. The court upheld TCQ's determination that Waterkeeper did not meet its burden to establish Ms. Wilson as an affected person. Waterkeeper doesn't meet its burden here either. Waterkeeper's call to invoke Article 3 and cite multiple irrelevant federal cases is a red herring. State law governs affected person determinations at TCQ, and state law is consistent with Article 3. The Commission and the Texas Legislature have an established process for evaluating mandatory and discretionary factors to assess a person's effectiveness consistent with Article 3. Waterkeeper invites the Commission to disregard that process and adopt an outcome that ignores applicable provisions in the Water Code and TCEQ rules. Even if we were talking about Article 3 in federal court, which we are not, Waterkeeper failed the basics. They offered only conclusory statements without any factual application of injury in fact, causation, or redressability, the three tenets of Article 3. Finally, Waterkeeper lacks organizational standing. This member doesn't have standing in her own right. Their stated mission and purpose centers exclusively on water. The organization's focus on water systems is irrelevant to TCEQ's evaluation of an affected person in an air permit context. Formosa respectfully requests that the Commission deny the hearing request and issue the draft permits. Thank you for your time.
Thank you very much. We'll hear from the Executive Director staff.
Good morning. Good morning, Commissioners, General Counsel, Public Interest Counsel. My name is Amanda Cranock with the Environmental Law Division, representing the Executive Director. With me and available to answer questions is Kara Hill of the Air Permits Division. This authorization, if issued, will allow the applicant Formosa Plastics Corporation to implement their flare improvement project. The applicant is proposing two separate projects in this permitting action. First, the applicant seeks to update the flaring emissions to comply with the EPA Risk and Technology Review, or RTR, for the ethylene production source category. Second, the applicant proposes an increase in annual maintenance startup and shutdown, or MSS, flaring emissions due to an additional required shutdowns. These projects span multiple permits and trigger federal PSD review, and therefore the corresponding air quality permits, PSD permits, and GHG permits are included in this review. The San Antonio Bay Estuarine Waterkeeper Organization, or Waterkeeper, is requesting a contested case hearing and named Ms. Diane Wilson as a group member that would have standing to request a hearing in her own right. For the reasons outlined below in the three filings submitted in this case, the Executive Director has concluded that Waterkeeper has not demonstrated that Ms. Wilson would meet the affected person standard in her own right. Therefore, Waterkeeper's contested case hearing request should be denied because it has not satisfied the requirements of 30 Texas Administrative Code, Section 55.205B of the TCEQ rules. First, Ms. Wilson resides more than 20 miles from Formosa. Distance and exposure time to a facility is a fact-specific determination which is considered in evaluating a request for a contested case hearing. While Ms. Wilson spends time near the facility, sometimes several hours, a few days a week, this exposure does not result in a prolonged impact that is different than members of the general public. Waterkeeper attempts to dispute the Executive Director's argument by stating the Executive Director does not cite a rule or case specifically implementing a distance requirement. However, the provisions of Texas Administrative Code Section 55.203C provide a non-exhaustive list of factors that are based on facts evaluated for each specific contested case hearing request. Two of these factors, whether a reasonable relationship exists between the interest claimed and the activity regulated, and the likely impact of the regulated activity on the health and safety of the person, are dependent on the distance and duration of exposure. Here, Ms. Wilson visits near the facility are intermittent, which directly impacts the relationship between her concern and the regulated activity and the likely impact of the regulated activity on her health and safety. Second, as Waterkeeper acknowledges, the Attorney General has stated that TCEQ rules and methods for evaluating affected person status comply with Article 3 standing requirements. It is not the Executive Director's position that large numbers of people must be affected in order to attain an affected person status. However, each requester must establish they are affected in a manner that is not common to the general public, as required by Texas Water Code Section 5.115A. Finally, Waterkeeper's argument comparing affected person status in a TIPDES permit to an air permit is not relevant because there is a difference in the type of exposure from an air permit versus a wastewater discharge permit. A recreational interest in, for example, using a water course used as a wastewater discharge route is different than a recreational interest near the general vicinity of an air emissions point regulated by an air permit due to the difference in exposure and use. Therefore, based on the arguments provided by the Executive Director, Waterkeeper's contested case hearing request should be denied. I am available to answer any questions. Thank you.
Thank you, Amanda. We'll hear from OPIC.
Good morning, Chairwoman Pope, Commissioner Gonzalez, Commissioner Miller, General Counsel and Executive Director. My name is Eli Martinez. I'm Senior Attorney with the Office of Public Interest Counsel for the record. Consistent with our response to the hearing request, OPIC supports the finding that Diane Wilson qualifies as an affected person under the applicable statutes and rules. Section 55203 of our rules defines an affected person as someone with a personal justiciable interest related to a legal right, duty, privilege, power, or economic interest affected by the application, not merely an interest common to the members of the general public. The rules outline several factors for this determination, including whether the claimed interest is protected by the law, such as the Texas Clean Air Act, the distance or other limitations on the affected interest, a reasonable relationship between the claimed interest and the regulated activity, the likely impact on the person's health, safety, and use of property, and the likely impact on their use of the impacted natural resource. For groups like San Antonio Bay Estuarine Waterkeeper, standing requires identifying a member with individual standing, here Ms. Wilson, whose interests are germane to the organization's purpose of protecting and educating about local bays and estuarine systems. As detailed in Waterkeeper's hearing request and the subsequent briefs on effectiveness, Ms. Wilson enjoys the aesthetic beauty and environmental health of the bays through regular recreational activities such as walking on the beaches, kayaking, and swimming with her children and grandchildren, particularly at Magnolia Beach. Additionally, as co-founder and executive director of San Antonio Bay Estuarine Waterkeeper, she conducts weekly monitoring visits up to 3 times a week since 2016 near Formosa's stormwater and wastewater outfalls. She accesses these sites by kayak, motorboat, or on foot to observe discharges and ensure compliance with the 2019 consent decree from the lawsuit against Formosa. These visits, which last hours at a time, expose her directly to the air quality in the areas potentially affected by the plant's operations. Based on these facts, OPIC concludes that Ms. Wilson has a personal justiciable interest in her own health, which is justiciable under the Clean Air Act and the Texas laws implementing it. Emissions from the facility, including contaminants like volatile organic compounds and nitrogen oxides, could affect air quality during her frequent visits. Her actual, repeated, and foreseeable presence in potentially impacted areas for recreation and consent decree monitoring demonstrates tangible exposure and reliance on these bays as natural resources. This could adversely affect her health and safety, as well as her use of the bays themselves for fishing, swimming, and monitoring, which distinguishes her from the general public. For these reasons, based on the factors in 30 TAC's Section 55203, Ms. Wilson's demonstrated recreational, environmental, and health interests qualify her as an affected person, thereby conferring standing to San Antonio Bay Estuarine Waterkeeper. We therefore recommend that the Commission grant the hearing request and refer this matter to the State Office of Administrative Hearings, as the relevant and material issues raised in Waterkeeper's hearing request are pertinent to your decision on this application. Thank you.
Thank you, Eli. Mr. Leach, you have 53 seconds left for your rebuttal.
Thank you. So I want to distinguish the Waterkeeper case quickly. It involved activities, recreational activities, miles from a proposed source, and there was no direct testimony establishing significant impacts from past activities. Those facts are not the facts of this case, so this case does not apply. The executive director says that recreational exposure can be sufficient to establish affected person status if substantial. The facts that we laid out here today establish substantial exposure as part of her recreational activities. Thank you.
Thank you very much, Mr. Leach. All right, this matter was continued from the October 8th agenda to allow the parties to provide additional briefing and oral argument on the issue of effectiveness. I appreciate the additional insight and argument provided by the parties. In its briefing, Waterkeeper provided additional information concerning the frequency and nature of its member, Ms. Wilson's, visits to the facility and the surrounding area. Given this information, I am no longer convinced that Waterkeeper has met the requirement to provide a member with standing to sue in her own right. I propose that we deny Waterkeeper's hearing request and issue the amended permits. I also propose that we adopt the executive director's response to comments. I'll stop here and ask Commissioner Gonzalez what she thinks.
I'm in agreement.
Thank you. Oh, you are recused.
Yeah, I'm recused still.
All right. I move that we, 1, deny the hearing requests of San Antonio Bay Estuarine Waterkeeper 2, issue the amended air quality permits to Formosa Plastics Corporation, Texas, as recommended by the Executive Director. And 3, adopt the Executive Director's response to comments.
I second.
All those in favor say aye.
Aye.
Aye. Thank you. Thank y'all. We're finished with old business, so we will hop to new business and number 1, please.
Old business.
I'm sorry?
We have old business too.
Oh, sorry. I'm jumping the gun today. All right, old business number 2.
So old business 2 is the consideration of the Office of Public Interest Counsel's 2025 annual report, and the Public Interest Counsel is here to present this item.
Good morning, Chairwoman, and good morning, Commissioners. For the record, I am Garrett Arthur, TCEQ Public Interest Counsel. Texas Water Code Section 5.2725 requires that OPIC annually report to the Commission and provide 1, an evaluation of the office's performance in representing the public interest in the preceding year, 2, an assessment of the budget needs of the office, including the need to contract for outside expertise, and 3, any recommended legislative or regulatory changes. The written report before you is intended to satisfy this statutory requirement for fiscal year 2025. As required, the report evaluates OPIC's representation of the public interest by using previously identified performance measures in 4 types of proceedings: environmental, district, rulemaking, and enforcement. This section additionally provides a real-world example of how OPIC fulfills its statutory duty to represent the public interest. Also, the report assesses OPIC's budget needs, including a discussion of contracting for outside technical support. To conclude, we appreciate the opportunity to review our work and provide this report to the Commission.
Thank you, Garrett. Mary, has anyone signed in on this item?
Yes, we have a number of people who have signed in and would like to address the Commission on this item. And to allow enough time for all who wish to speak to be heard during this meeting, the Commission will limit initial comments from each speaker to 3 minutes and extend that time if the Commission needs further discussion with the speaker. With that, I'll begin calling the names. First, I believe this person is virtual, Pankaj Wadhwa.
Are you there?
It looks like they're not online. They're not seeing them online. So we'll go to the next person. Laura Colangelo.
Good morning, Commissioners. My name is Laura Colangelo. I'm the Executive Director of the Texas Private Schools Association. I represent the 950 private accredited nonprofit schools across the state serving children and families. I'm speaking in strong support of the proposed amendment to Chapter 55 of the Texas Clean Air Act, which would allow the recognition of schools as affected persons in contested case hearings involving concrete batch plant permits. For schools, the initial permitting process is the first and best opportunity to protect student health and safety. When a concrete batch plant applies for a permit, TCEQ typically offers a single period for public notice, public comment, and request for contested case hearings. Without affected person status, schools have no right to participate in contested case hearings, the only setting where they can present evidence, cross-examine experts, and seek enforceable safeguards. Once a permit is issued, that opportunity to preemptively address the impacts of a facility is gone. There is no second opportunity to request a hearing, challenge the permit, or seek additional safeguards, even if new environmental data later shows increased risk or if neighborhood conditions change. This means a plant can legally operate for years right next to a school, and even if conditions with the existence of the plant become such that a hazard to students arises, the school has limited, if any, meaningful ability to act on behalf of its students. Although schools may provide public comment, this provides them no enforceable rights. The agency must issue a written response, but is not obligated to modify or deny a permit based on those comments. Instead, only those recognized as affected persons can appeal or reply, as the ability of the schools to appeal is unclear, given that they have no right to the contested case hearing, which courts have found to be a prerequisite to judicial review. So while schools can comment, they cannot compel change. The problem is expounded by exceptions in the current permitting process. Current regulations allow certain temporary concrete batch plants to relocate to a site where a similar permit existed within the past 2 years without any new public notice or comment period, even though public notice for such a facility may have occurred years earlier. Even more concerning, certain designated temporary plants are completely excluded from notice requirements that can operate at the same site for years without any public comment, even though they may be operating just a few hundred feet from a school. Affected person status is generally limited to residents living within 440 yards of a proposed plant. Private schools, however, serve students from across their city and beyond, well outside that narrow radius. Parents of those students may not qualify individually for affected person status. That would leave schools as the only logical entities capable of advocating for the health and safety of their student body. But schools are not recognized under current rules, leaving no one withstanding to advocate for the children who spend their days in these classrooms and playgrounds. The one-size-fits-all approach of the standard permit raises particular concerns when such sensitive populations are impacted. The proposed amendment would close that gap, and we appreciate this recommended change.
Thank you. Appreciate your comments.
Jenny Andrews.
Good morning, Commissioners. My name is Jenny Andrews, and I'm a policy analyst at the Texas Catholic Conference of Bishops. I'm here today in strong support of the proposed amendment to Chapter 55, which would recognize churches, schools, child care facilities, and hospitals as affected persons in contested case hearings involving concrete batch plant permits. The bishops strongly support the recommendation from the Office of Public Interest Counsel for a legislative change that would allow these facilities to request contested case hearings on an application for a concrete batch plant standard permit within 440 yards of their facilities. Under current rules, only those with permanent residences may request such hearings, which has been a barrier for our ministries and the vulnerable people they serve. We have had many of our facilities unable to be heard in this process due to the current restrictions on hearings. The public health complications of those who visit our facilities, children, the elderly, and those with health conditions, deserve protection from potential exposure to air contaminants. The hospital example given by OPIC in their recommendation is of particular interest to us. A hospital located within 440 yards of a proposed plant may reasonably fear that particulate matter would harm patients, especially those with respiratory and pulmonary conditions. Yet because hospitals are not deemed affected persons under 382.058C, their concerns cannot even be considered in a hearing. As OPIC noted, without a change, the Commission will continue to face a statutory obstacle to granting a hearing to certain vulnerable populations and other important receptors within 440 yards of a proposed concrete batch plant. For schools in particular, there is a conflict in the law with regard to their ability to protect students and staff from air contamination. Under Chapter 30 of the Texas Administrative Code, TCEQ must consider any possible adverse short-term or long-term effects of air contaminants on nearby schools. However, because schools cannot currently obtain a hearing, there is no formal process to ensure that this consideration actually occurs. When concerns are raised, the Commission may respond that the school lacks jurisdiction over land use issues, effectively sidestepping the intent of the rule. We thank the Office of Public Interest Counsel for this recommendation to broaden the definition of affected persons, and we look forward to working with the legislature and the Commission to provide those who attend our schools, churches, childcare facilities, and hospitals the opportunity to have their concerns heard and represented. Thank you for your time.
Thank you very much.
I have a question.
Yes, ma'am.
Do you understand, this is a report, we're not actually considering any kind of change and we can't make legislative changes?
I do understand that you can't make legislative changes. I was just here to thank the OPIC office for the recommendation and to say that we support it.
Thank you.
Thank you.
Mary Andrew, I believe this is somebody who's virtual.
Ms. Andrew?
Hey, good morning, Commissioners. My name is Mary Andrew, and I'm the mother of a kindergartner who attends school next door to a concrete batch plant. Thank you for the opportunity to speak today in support of OPIC's recommendation that schools, daycares, and early learning centers be included with permanent residents as affected parties in contested case hearings for concrete batch plants. My daughter, Madeline, was born with congenital heart disease. Despite our hopes to avoid intervention until her teenage years, my husband and I found ourselves with a 4-year-old on a bypass machine in early July. We were blessed with a successful surgery, a donor pulmonary valve, and a little girl with a bright future ahead. We meticulously planned her surgery and recovery so that she was well enough to start kindergarten on time. By September, her only restrictions involved backpacks and monkey bars. Her sternum had to be split lengthwise during surgery, and her chest bone had not yet healed. My only worry at the time was overburdening school staff to keep an extra eye on her during recess. We only learned about a newly active batch plant a few days before school began. Both my husband and I work in the energy space, and neither of us knew a thing about the industrial hazards of a facility sharing a fence with our daughter's school. Through my own extensive research, I learned that these plants are not allowed near residential areas, and for good reason, and struggled to understand why a school would be any different. We have since navigated each school day with a heightened sense of anxiety. We keep logs of sights, smells, and sounds during drop-off and pickup. We check the emissions monitors and track her physical symptoms, unsure if she is safe at the school she loves so much. Including schools in the affected party status is not about opposing industry. It's about prioritizing children's health, quietly, fairly, and with common sense. We strongly support OPIC's recommendation to give our places of learning the same protection extended to homes. Thank you for your time and for considering the long-term health of our great state's youngest residents.
Thank you very much.
We have Michael Renna.
Morning, Commissioners. Can you hear me?
Yes.
Excellent. For the record, my name is Michael Renna. I am not an attorney, but I serve as a leadership role at Investex Limited, a commercial real estate development company here in Texas. I'm also the father of a child who attends a school in Houston that is just next door to an active concrete batch plant. In 2022, my company complied with full compliance with all of TCEQ's environmental and construction standards. We invested the time, effort, and resources to meet every condition. Because of what's responsible, that's what responsible development looks like. I can say from firsthand experience that the standards are not arbitrary, they protect our communities. They ensure accountability, and they are what make Texas a place where industry and neighborhoods can coexist responsibly. That's why I'm here today, not to criticize, but to ask the same standards be applied consistently. Because our industrial facility had to meet clear separation distances, dust control measures, and air quality safeguards, then surely the concrete batch plant operating next door to a school should be held to the same bar. I want to take a moment to commend the Office of Public Interest Counsel for their recent recommendation and that reflects what Texans expect from good governance, a commitment to fairness, transparency, and public health. OPIC's work demonstrates strong economic development and community safety that are not opposing goals. They are two sides of the same principle, stewardship. Today, I'm urging TCEQ to adopt OPIC's recommendation and ensure that its own permitting standards are upheld uniformly across cities, across industries, and across Texas. Doing so will restore public confidence and send a clear message that compliance isn't optional, that the health of our children carries more weight than the cost or convenience. We value growth and opportunity, but these things mean nothing if we can't also guarantee the right to breathe clean air at school. I appreciate your time, your service, and the work you do to protect Texas families. Thank you.
Thank you so much. Appreciate your comments.
Gabrielle Hatton.
Good morning, and thank you for your attention to this important matter.
Good morning.
My name is Gabrielle. Oh, can we hear?
We can hear you.
Okay, thank you. My name is Gabrielle Hatton. I'm here today as a mother, a physician, and a concerned citizen. My son attends an elementary school that sits just 300 feet from an active concrete batch plant. Every day when I drop him off, I see the dust rising in the air and wonder what it's doing to his lungs. and to every other child learning and playing there for thousands of hours per year. No parent should have to wonder if the air their child breathes at the school he loves is putting his health at risk. As a physician, I care for many of the same families who live and work in the shadow of these industrial operations. We see health impacts every day: children with asthma, adults struggling with chronic respiratory illness, and families living with suffering. That's why I'm here today to strongly support the Office of Public Interest Counsel's recommendation. This recommendation is an important step toward protecting our communities by ensuring that schools, churches, and hospitals are not placed side by side with concrete batch plants or crushing facilities. Now I'd like to share a moment from my workplace. I'm walking into the emergency room and a patient is being rushed in on a stretcher. He's about 40 years old, but he looks thin, weak, and is far older than his age. He's gasping for air, his chest heaving with effort. His eyes are dull, unfocused, and between breaths, he seems almost lifeless. The team quickly connects him to monitors, starts oxygen through a pressurized tube, and sets up nebulizers to help him breathe. But his body is exhausted. This is what pulmonary fibrosis looks like, a disease that scars the lungs, steals breath, and has no cure. As I leave work, I can't help but wonder, if we don't act now and do what we can, if we continue to allow industrial plants to operate immediately beside our schools, hospitals, and neighborhoods, will I one day see the same scene again? But this time, will it be my son on that stretcher? We have the opportunity now to make sure this never happens. Please endorse the new policies that strengthen the permitting process for concrete batch plants to protect our children, our patients, and our future. I want to thank the TCEQ for your time and your service to our state.
Appreciate you. Thank you very much.
Austin Baker.
Can you hear me okay?
We can.
All right, thank you. For the record, my name is Austin Baker. Good morning, and thank you to the TCEQ commissioners for the opportunity to share my support for OPIC's legislative change recommendation on affected persons and hearings on concrete batch plant registrations. The proposed change recognizes the impact that concrete batch plants have to schools and families when permitted and located in close proximity under the 440-yard limit. I and other affected parents are here to underscore that we understand the impact as parents of children who attend school directly next to a concrete batch plant facility. We live this impact every day. It is important to acknowledge this because the positive effect this change recommendation can have, by understanding the heartache, anxiety, and detrimental health effects, it will hopefully help prevent in the future. I have a 5-year-old son and a 3-year-old daughter who attend school where a plant has begun operations in the middle of this year. A new part of our daily routine, in addition to the normal chaos of getting your kids fed, dressed, and out the door on time, is checking the school's air quality monitoring dashboard to see if there's another spike in particulate matter that morning, meaning no recess or outdoor time for the kids. Trying to explain to your 5-year-old why the air wasn't healthy for them to play in today, but why they shouldn't be afraid of being outside or afraid of going back to school the next day. Reading emergency response procedures and plans as the school does its best to keep the children safe in the event of a bag or safety shutoff failure that threatens the very HVAC system that thankfully filters the air indoors for them. I would like to thank OPIC for the recognition that our most precious and vulnerable population, the children of this great state, need to be afforded critical procedural protections in the cases where concrete batch plants are close enough to impose actual harm, and the additional burdens on parents, teachers, and staff to now manage an entire class of risks associated with batch plants that are unduly burdensome. The proposed changes to this section are critical to protect the health and safety of Texas children, and God willing, will get us to a place where parents do not need to worry about the dangers of close proximity concrete batch plants and the dangers that they pose to their children. Thank you, OPIC, for leading this effort with your recommendation. Thank you, TCEQ, for your continued support and work to protect Texas children. Thank you for your time.
Thank you very much.
Jason Hale.
Is he virtual?
He's virtual.
Mr. Hale? All right, let's move on.
Okay, Catherine Guerra.
Good morning, Catherine.
Good morning, Commissioners. I'm Catherine Guerra with Public Citizens Texas Office. Public Citizen is a nonprofit consumer advocacy organization with over 1 million supporters and members that champions the public interest in the halls of power. I'm speaking today in support of OPIC's item. We are grateful for the work of the Public Interest Council and for their continued legislative recommendations and advocacy on behalf of communities to mitigate the impact of polluters on communities across Texas. I'd like to emphasize the importance of the Public Interest Council and urge the Commission to really consider its advice in your decision-making processes. OPIC ensures that communities and not just industry have a voice in these processes. And while we understand these are legislative recommendations that require legislative action, which we will champion again during the legislature's next regular session, we also know that TCQ's enforcement policies, rulemaking, and rule program implementation for batch plants have been and continue to be harmful to communities. You've heard several examples of those harms from concerned parents and administrators today to support the OPIC recommendation that schools should have affected party status. They are certainly affected and should have a legal avenue to challenge that. Legal challenges can be effective, and just last week in Houston, that community won their lawsuit they filed against the TCEQ for its attempt to give concrete batch plant operators up to 10 additional years to comply with those new pollution standards. The court found that this pollution grace period was arbitrary, capricious, and violated Texas law. These comments were presented to the Commission by advocates during the rulemaking process, and still in their response to comments, the ED dismissed them, and this Commission adopted them, as you've done before despite similar concerns. Public concern about potential health impacts of batch plants led the agency to conduct the air quality analysis, which prompted stronger pollution limiting requirements for those batch plants in the first place, and we should really be listening to these communities. When OPIC raises a concern on the public's behalf, whether it's about public notice or gaps in environmental analysis or weakness in permit conditions, the Commission should heed them as early warnings. OPIC has been sounding the alarm about concrete batch plants and their harmful impact on nearby communities with this legislative recommendation since at least 2018. We'd like for this Commission to take stronger steps to protect the public from these facilities as well. I do have a couple of small requests of OPIC. We'd like to see included in this annual report the number of meetings and hearings, not just the number of meetings and hearings attended, but also the total number of cases where OPIC's recommendation to this Commission reflected the concerns of and aligned with the community's requests. And we'd also like a value that indicates effectiveness or the number of instances where the community achieved its desired outcomes because of OPIC's recommendation and involvement. Finally, I would like to request that all of OPIC's annual reports be made available on the TCQ's website for transparency. Reports after 2021 are not available online. Thank you so much for your time.
Thank you.
That's all that we have signed in on this one.
Okay. Executive Director, staff.
Good morning, Chairwoman Pop, Commissioner Gonzalez, Commissioner Miller, General Counsel, and Public Interest Council. Primarily, just wanted to express appreciation to the Public Interest Council for preparing the report. We have no comment on proposed legislative measures.
Thank you. Appreciate it. This report requires no action. I appreciate the report, and I want to thank Garrett and all his staff for putting it together. Colleagues?
I want to thank staff for their work on this report as well. Public Interest Council obviously puts a lot of time and effort into representing the public interest. And I appreciate the report. As the chairwoman said, we don't take action today. But I wonder if OPIC's resources could be better employed if rather than focusing on 100% participation, they have focused on selecting specific matters and rulemakings that have a significant impact on the public interest. After speaking with Mr. Arthur and Mr. Martinez regarding OPIC's role, we realized that we have not reevaluated OPIC's performance measures in over a decade, including their responsibilities. Also, in those visits, I came to believe that it could be beneficial to develop a rule that better defines the office's role. So I would direct the General Counsel to work with OPIC and the ED on the Commission's behalf to both revisit OPIC's performance measures and initiate a rulemaking to better define their role.
Tanya, any comments?
Yeah, I, along with Commissioner Gonzalez, agree that we haven't looked at OPIC's performance measures since 2012, and it may be time to re-examine those, and I'd like to see them be more meaningful in an examination of what their actual performance is. I have some ideas on that, but I think opening a rulemaking would be good on that. I do appreciate the report and your work on it and staff's work on it.
Thank you very much. A decade is a long time to go. My son was 2 when the last performance measures were looked at. So I think it's time. Stay tuned. Thank you. Right. Now we're going on to new business.
Correct. We're at new business 1, which is the consideration of the proposal for decision and proposed order concerning the petition for the creation of Ellis County Municipal Utility District, FM 984. The parties have been notified that the petitioners, the protestant, the ED, and OPIC will each have 5 minutes of oral argument time. The petitioner should speak first and may reserve a portion of his time for rebuttal, as the petitioner bears the burden of proof in this matter. And so with that, we'll begin with the petitioner, Mr. Sellinger.
Is Mr. Sellinger here?
Check if he's online too, just a second. Doesn't appear to be online either. Would you like to go to the protestants?
I would. Good morning, Ms. Albright.
Good morning. Sorry, I was further away than I thought. It was a long walk. Good morning. My name is Stephanie Albright with Bickerstaff Heath Delgado Acosta, and I represent Ellis County and the City of Venice that are protestants in this matter. The county and the city respectfully request that you accept the PFD and deny the petition to create Ellis County FM 984 MUD. First, the applicant has failed to meet the burden to show that the development is feasible, practical, necessary, and would be a benefit to the land in compliance with Texas Water Code Section 54.021. Significant costs were omitted from the preliminary engineering report and the application in this matter. The applicant tried years later in the contested case hearing process to submit unreliable cost quotes with bids obtained years after the date of the preliminary engineering report, and they were only provided in the contesting hearing process as part of the testimony. So neither the TCEQ had the opportunity to review any of this information, nor did the protestants have the opportunity to review this information. And they also weren't a part of the application or submitted at the time appropriate for costs. However, even if allowed, this later provided information did not support the preliminary engineering report, but added costs and conflicted with costs and facilities in the preliminary engineering report in several areas. This conflicting and unreliable information only added to the confusion regarding the project and the costs that are applicable to this project to determine whether or not they were reasonable. Even if these costs were to be admissible, which the protestants don't believe that they are, the costs are grossly underestimated, and the applicant offers conflicting information on what costs and what facilities are necessary for this project. The applicant, for example, proposes that only 3 groundwater wells are needed to serve over 5,000 residents. The protesting expert has showed that upwards of 17 groundwater wells would be necessary, including the buffer zones that would be required for these groundwater wells. Additionally, the wastewater facilities themselves are grossly underestimated on what size plant would actually be needed. The preliminary report estimates a 100,000 gallon per day wastewater treatment plant. The permit that the applicant has requested is for 405,000 gallons per day, but the preliminary engineering report states that the wastewater treatment facilities would need to be 533,000 gallons per day. Additionally, there's discrepancies in the lot sizes. The preliminary engineering report, the testimony of the applicant, as well as the actual closing arguments of the applicant have shown different lot sizes, which can greatly affect the cost and the reasonability of cost. And so the analysis basically is just not able to be done in this application. These discrepancies are egregious and would have a significant impact to future tax rates and utility rates within the proposed district. The county and the city agree with the executive director and the administrative law judge and respectfully ask that the commission adopt the proposal for decision. Thank you.
Thank you, Ms. Albright. We'll go to the executive director staff.
Good morning, Chairwoman, Commissioner, General Counsel, and Public Interest Counsel. For the record, my name is Cole Manley of the Environmental Law Division, and I'm here today on behalf of the Executive Director. With me is Justin Tack of the District Section. The ED recommends adopting the ALJ's order and denying the petition. The issue in this case was the additional evidence the applicant submitted for consideration at the hearing on the merits. The additional evidence included revised costs related to water supply, wastewater treatment, and the configuration of the district itself. Upon review of the applicant's testimony exhibits, the ED determined that this additional evidence conflicted with the materials that were originally included in the petition. Pursuant to Texas Water Code 54021, the Commission may create a district if it finds the project is feasible, practicable, necessary, and would be a benefit to the land to be included in the district. Due to multiple discrepancies with the applicant's direct case, the ED was not able to conclude that the creation of the district would be practicable or feasible. Accordingly, the ED could not support the petition as the applicant did not meet its burden of proof the petition met all applicable statutory and regulatory requirements. The ALJ agreed with the ED's position and recommended denial in the PFD. Therefore, the ED recommends the Commission deny the petition and revise the findings of facts as specified in our exceptions. Thank you, and we're available for questions.
Thank you very much. OPIC?
Good morning, Chairwoman, Commissioners, General Counsel, and Executive Director. My name is Eli Martinez, Senior Attorney with the Office of Public Interest Counsel, for the record. We participated as a party to this case, and after careful review of the evidence, applicable law, and the proposal for decision, OPIC recommends that the Commission deny the petition. The burden is on the applicant as the moving party to prove by preponderance of the evidence that the petition meets all applicable requirements under Article 16, Section 59 of the Texas Constitution, Texas Water Code, Chapters 49 and 54, and Chapter 293 of the Commission's rules. The Commission shall grant a petition for a municipal utility district if it conforms to Texas Water Code 54015 and the project is feasible, practicable, necessary, and beneficial to the land. Factors in this analysis include reasonableness of costs, tax rates, and total tax assessments, among others. The Commission may exclude non-benefited land, redefine boundaries, or deny the petition if non-conforming or not feasible, practicable, and necessary, and beneficial. OPIC independently evaluated the evidence in our closing arguments and concluded the applicant failed to meet its burden due to irreconcilable deviations between the final engineering report and pre-filed testimony on water supply costs, wastewater treatment costs, and number of homes. These factors rendered the project infeasible and impracticable under Texas Water Code Section 54021 and Rule 293.11. The ALJ's PFD aligns with this position, finding the applicant did not prove compliance. Firstly, the applicant's pre-filed testimony introduced water supply costs that were absent from the final engineering report, which created a substantial gap in the financial and technical foundation of the MUD and severely impacted the project's feasibility. Specifically, while the engineering report estimated water system costs at some $7.6 million, corrected estimates, including 17 wells and other critical components, escalated costs to $46.6 million. Further, the Pearland's groundwater conservation district's limit of 26.5 million gallons per year contrasts with the MUD's projected demand of 232.5 million gallons, which amounts to a 776% exceedance, and failure to address this constraint coupled with inconsistent well proposals demonstrates impracticality of the district. Secondly, for wastewater treatment costs, applicant's estimate of $2.4 million for a 405,000 gallons per day plant underestimates today's prevailing rates of $18 to $20 per gallon. A more accurate figure would be around $15 million for a properly sized 640,000 gallons per day plant that accounts for water treatment waste. The proposed capacity is also insufficient at 405,000 gallons per day, where need is shown to be between 533,000 and 640,000 gallons per day. The plant's location also violates Rule 309.13 by encroaching on residential lots, necessitating removal of 9 lots on this basis, plus another 204 for well easements would reduce the tax base. Thirdly, there's an inconsistency in the number of homes. The applicant's testimony represented 1,522, whereas the engineering report cited 1,517. Lot removals would further reduce viable homes, impacting infrastructure sizing, tax rates, and bonds. Lastly, there are procedural barriers to revisiting this data, as the ED cannot revise findings without new notice for major amendments. The ALJ concluded these inconsistencies demonstrate the applicant did not prove the project is feasible, practicable, necessary, or beneficial, and OPIC agrees. Our analysis confirms the applicant failed to meet its burden by preponderance of the evidence. The petition does not comply with statutory requirements, and the deviations render it unreliable. Therefore, OPIC recommends the Commission adopt the PFD and deny the petition for creation of Ellis County Municipal Utility District FM 984. Thank you. I'm available for any questions.
Thank you, Eli. Appreciate it. I have been notified that the petitioner, Mr. Sellinger, is not registered and he is not online, so we will move on. Colleagues, item 1 requires us to consider the proposal for decision concerning a petition to create a municipal utility district and the granting of road powers. I agree with how the ALJ handled the case and would adopt the proposed order, but I have some minor changes to recommend. I agree that the petitioner did not meet its burden to demonstrate that the project is feasible and practical and is necessary and would be a benefit to the land to be included in the district, particularly as it relates to the reasonableness of the proposed construction costs and the corresponding effects to projected tax rates and water and sewer rates. I recommend that the Commission adopt the changes to findings of facts numbers 5, 7, and 26 recommended by the ED's exceptions, which are generally agreed to in the ALJ's reply to exceptions. However, I would add the proposed language for finding of fact number 7 to the finding instead of replacing it. I'd also add 2 additional findings of fact to memorialize that the record supports determining that the district, its systems, and subsequent development will not have a reasonable effect on land elevation and subsidence. The ALJ failed to propose any findings on these conclusions of the law in the order, although she discussed both in the PFD analysis. I would also correct the findings of fact 25 and 27 because the ALJ erroneously incorporated an inaccurate statement from the ED's technical memorandum and closing argument that misstated the district's combined projected tax rate as $1.04 versus what per 100 valuation when applicants sought, and 30 Texas Administrative Code section 293.59K and L limit the combined projected tax rate to $1 per $100 valuation. I'm going to make a motion, and we can talk about it after. Do you have anything to say?
No, I agree. Thank you.
I agree.
Great. I move that we adopt the administrative law judge's proposed order with the changes to findings of fact 5, 7, and 26 recommended by the ED's exceptions, which are generally agreed to in the ALJ's reply to exceptions. However, add the proposed language for finding of fact number 7 that the finding to that finding rather than replace it. Because the proposed order concludes that the district, its systems, and subsequent development will not have an unreasonable effect on land elevation under the Texas Water Code 54.021B3A, or an unreasonable effect on subsidence under Texas Water Code 54.021B3B, but inadvertently omits findings of fact to support the conclusion, add the following findings of fact. For 17I, applicant does not plan to significantly alter land elevations or the natural topography of land in the district, and subsidence is not prevalent in Ellis County. And for findings of fact 17.2, the district and the systems and subsequent development within the district will not have an unreasonable effect on land elevation or subsidence. Correct the findings of fact number 25 and 27 because the ALJ erroneously incorporated an inaccurate statement from the ED's technical memorandum and closing argument that misstated the district's combined projected tax rate at $1.04 per $100 valuation when applicants sought, and 30 Texas Administrative Code 293.59 K&L limits the combined projected tax rate to $1 per $100 valuation as follows. Findings of fact 25. Based on the applicant's engineering report, the combined projected tax rate was $1 per $100 assessed valuation for 100% financing. For findings of fact 27, the combined projected tax rate for the district must not exceed $1 per $100 valuation pursuant to 30 Texas Administrative Code, Section 293.59K and L. Finally, I deny the petition for creation of Ellis County Municipal District, FM 984.
Second.
All those in favor say aye.
Aye.
Aye. Thank you. The motion passes. We'll move on to item number 2. We'll give everyone a chance to move.
New business 2 is the consideration of the ALJ's proposal for decision and proposed order concerning the application by Stephen Richard Selinger for a new TIPDES permit. The parties have been notified that the applicant will have 5 minutes, protestants collectively will have 5 minutes, and the ED and OPIC will each have 5 minutes of oral argument time. The order of presentation will be applicant, followed by protestants, the ED, and OPIC. Applicant may reserve a portion of his time for rebuttal as he bears the burden of proof in the matter. Our applicant for this is Mr. Selinger, but again, Mr. Selinger is not registered and is not online currently.
All right, we'll move to the protestants. Good morning again, Ms. Albright.
Good morning again. My name is Stephanie Albright, and I represent Ellis County and the City of Venice as protestants in this matter. The county asks that the commission deny the wastewater permit application because the proposed discharge will violate the Texas surface water quality standards, and the draft permit is not protective of human health, terrestrial life, and aquatic life. First, regarding this contested case hearing, the applicant's testimony is just simply not reliable. The applicant's sole witness was not credible and was not qualified to give the opinions related in his testimony. The county and the city had no meaningful opportunity to cross-examine this witness. The purported expert attended the virtual hearing on the merits via landline versus on camera as all the other parties had done. He further did not have any documents related to the case for reference, including his own testimony, and was not able to answer questions about his testimony, the opinions therein, or any of the documents that were supporting the application. The protestants were thus unable to meaningfully participate in the hearing and requested that the applicant's testimony be struck for this reason. A wastewater permit is a privilege, and when significant evidence is presented to rebut the presumption that the permit meets all applicable laws, the applicant must produce testimony to overcome this evidence that are submitted by the protestants. In this case, they simply were not able to do that, and they had no meaningful, we had no meaningful ability to be able to cross-examine their witness. Further, the application did not comply with the state's regionalization policy. The Texas legislature has directed that the TCEQ observe the regionalization policy in Chapter 26 of the Texas Water Code. And the TCEQ has the authority to deny wastewater applications where there are existing and available regional wastewater systems. In this matter, the county and the city have provided evidence showing that both the city of Waxahachie and the city of Ennis have existing and available wastewater systems and are willing to provide wastewater service to the development. However, the applicant's witness, in a brief cross-examination that we had, admitted that the applicant did not pursue service from either of these cities, even knowing what's available, nor did they request additional details relating to the terms of the service from either of these cities. The application should thus be denied based on Chapter 26 of the Texas Water Code because the applicant has the opportunity to participate in existing regional wastewater systems. Further, the draft permit is not protective of water quality. Specifically, the nitrate and the sulfate levels in the receiving waters will be negatively affected by the proposed discharge in this permit. The protestant submitted testimony from its expert showing that TCEQ's model evaluation fails to take into account existing nutrient and nitrate concentrations in Waxahachie Creek, including in its modeling data the nitrate levels that are far below the levels that are indicated in the 2024 integrated report. Allowing the proposed discharge will further increase nitrate levels in the receiving waters that are already noted as a concern in the integrated report. Additionally, the protest has presented evidence that the treatment processes proposed by the applicant will not treat or reduce sulfate in the effluent, and the TCEQ's model does not take sulfate into account. Lake Bardwell, downstream from the proposed discharge, which is also a primary drinking water source for the region, is currently listed as impaired for sulfate. The proposed source of water for this subdivision is groundwater, and this is a water source that our experts have shown that has a higher sulfate concentration. Because the wastewater treatment process proposed will not treat sulfate, the concentration of sulfate in the groundwater will go directly into Waxahachie Creek and then shortly thereafter into Lake Bardwell. Without adequate measures to address the nitrate and sulfate levels, the draft permit will not be protective of surface water quality and will violate the Texas surface water quality standards. For these reasons and for the county and the city's reasons in their closing arguments, we urge the commission to deny the application and overturn the PFD. Thank you.
Thank you, Ms. Albright. We'll hear from the executive director staff.
Good morning, Chairwoman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Fernando Salazar Martinez of the Environmental Law Division, and I'm representing the Executive Director. With me today from the Water Quality Division is Jenna Luke, John Hearn, Jim Michok, and Peter Schaefer. The Executive Director recommends that the Commission adopt the ALJ's proposal for decision and proposed order as revised by the ALJ in their acceptance letter and issue the permit without changes. The Executive Director agrees with the ALJ's findings of fact and conclusions of law as referenced in their PFD on agreed issues 1 through 6. After examining the evidence on the record, the ALJ found that the Commission should not deny or alter the terms and conditions of the draft permit based on consideration of need under Texas Water Code Section 26.0282 and the general policy to promote regional or area-wide systems under Texas Water Code Section 26.081. And that the draft permit is adequately protective of water quality and the existing uses of the receiving waters. The draft permit is protective of groundwater. The draft permit complies with all applicable location restrictions, including those under 30 Texas Administrative Code, Chapter 309. The representations contained in the application are accurate, and that the draft permit provides adequate licensing requirements for the operator of the facility in accordance with 30 Texas Administrative Code, Chapter 30. Regarding Issue 1 concerning regionalization, the ALJ found that the protestants did not rebut the prima facie demonstration because the protestants did not present sufficient evidence showing a violation of the state's regionalization policy or that the applicant failed to demonstrate the need in his application for the proposed permit. Regarding Issue 2 concerning water quality, the ALJ found that the applicant met his burden and the ED's analysis addressed the concerns raised by the protestants. Regarding Issue 6, concerning operator requirements, the ALJ found that the draft permit's licensing requirements, which require the operator to hold a Class C license or higher, are sufficient. And finally, regarding Issues 3, 4, and 5, the ALJ's PFD notes that the protestants did not present arguments on these issues. In conclusion, the Executive Director respectfully requests that the Commission adopt the ALJ's PFD and proposed order, including the revisions referenced in their exceptions letter, and issue the permit without changes. Thank you, and we're available for any questions.
Thank you. Appreciate it. OPIC?
Good morning again. Eli Martinez with the Office of Public Interest Counsel for the record. We participated as a party to this case, and after a careful review of the evidence, applicable law, and the proposal for decision issued by the State Office of Administrative Hearings, OPIC recommends that the Commission grant the permit as proposed in the draft permit. Because this application is governed by Senate Bill 709, the administrative record establishes a prima facie case that the draft permit meets all state and federal requirements and would protect human health, safety, the environment, and physical property. The burden of proof remains on the applicant as the moving party by preponderance of the evidence, but it can be met through the administrative record unless rebutted. 6 issues were referred to SOA by the Commission, and OPIC independently evaluated the evidence on each issue. The ALJ's PFD aligns with OPIC's position that the applicant satisfied all requirements after considering the evidence from all parties, including the protestants' concerns. The first issue concerned need and regionalization. The applicant demonstrated a clear need for the wastewater treatment facility, as no alternative facilities exist within a 3-mile radius per TCEQ's wastewater outfalls database. The City of Waxahachie Certificate of Convenience and Necessity is 2.1 miles away with no overlap. Although the City of Ennis and Waxahachie offered service, the applicant's cost analysis showed the building, the wastewater treatment facility at a $2.8 million initial cost is far less expensive than connecting to Ennis Utilities at a $6.8 million initial cost with higher annual costs, making regional alternatives cost prohibitive. This complies with Texas Water Code Section 26.081's policy to promote consolidated systems while allowing for practical exceptions. The ED's testimony supported this, and the ALJ found insufficient rebuttal of the prima facie case. The second issue related to surface water quality. The executive director's aquatic scientist, Jenna Lug, conducted an anti-degradation review, aquatic life use assessment, and screenings for parameters like dissolved oxygen, total dissolved solids, chloride, sulfate, and nutrients. The review confirmed no in-stream toxicity, no violation of Texas water quality standards, and no exacerbation of Bardwell Reservoir's sulfate impairment, which is listed under the 2022 Clean Water Act Section 303D list. The draft permit's effluent limitations developed under the Federal Clean Water Act, Texas Water Code, Chapter 307 of the Commission's rules, and TCEQ's 2010 implementation procedures ensure protection of aquatic life and human health. The third issue was groundwater protection. The executive director provided credible evidence the permit will comply with the Texas surface water quality standards and surface water protections, and so the discharge should not negatively impact groundwater quality. The fourth issue concerned location restrictions. The facility is above the 100-year flood level, not in wetlands, meets buffer zone requirements for odor control, which is 150 feet from property lines, and has no nearby public or private water wells per 30 TAC Section 309.13. The fifth issue concerned accuracy of representations, and we found the applicant met his burden with respect to this issue. The final issue related to operator licensing, and the draft permit requires a Class C or higher license with on-site supervision 5 days per week and availability 7 days per week, consistent with 30 TAC Section 30.350. The ALJ's PFD also addressed transcript costs, apportioning the full cost to applicant due to his failure to timely engage a court reporter or ensure that the transcript was filed as required, and because only he will receive a financial benefit from the permit. We concur with this decision. In conclusion, OPIC's independent review confirms that the applicant met the burden of proof by preponderance of the evidence, as supported by the administrative record and unrebutted on key points. The draft permit complies with all applicable requirements. Therefore, OPIC recommends that the Commission adopt the PFD and grant the requested TIPD's permit as drafted. Thank you. I'm available for any questions.
Thank you, Eli. Well, item number 2 involves a TIPD's permit application to authorize the discharge of treated domestic wastewater at a daily average flow not to exceed 400,000 gallons per day in the final phase in Ellis County. I agree with how the ALJ handled the case and would adopt the ALJ's proposed order with the changes that she recommended in her September 4th, 2025 letter. Stop and ask Katarina what she thinks.
I'm in agreement.
Thank you. Tanya?
Agreement.
Do I have a motion?
I move that we adopt the ALJ's proposed order as revised by the ALJ's letter dated September 4th, 2025, that we issue the draft permit as recommended by the executive director, and that we adopt the ED's response to comments.
Do I have a second?
Second.
All those in favor say aye.
Aye.
Aye. Thank you. The motion passes. Move on to item 3.
Item number 3 is the consideration of an application by Raptor Ready Mix for issuance of air quality standard permit for concrete batch plant, registration number 177217L002. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
All right, Raptor Ready Mix has applied for authorization of a concrete batch plant. For this type permit, Texas Health and Safety Code Section 382.058C specifically mandates that only those persons who reside in a permanent residence within 440 yards of the proposed plant qualify as an affected persons. In my review of the hearing request in this matter, none have demonstrated that they live within the 440 yards of the proposed concrete batch plant. So based on Texas Health and Safety Code Sections 382.058C, I believe that we are compelled today to deny all hearing requests as a matter of law. I've also reviewed the registration and the ED's response to comments. I would also issue the registration and adopt the RTC. Katerina?
I agree.
Tanya?
I agree.
Thank you. Do I have a motion?
I move that we deny all hearing requests, issue the air quality standard permit for concrete batch plant registration number 177217L002 to Raptor Ready Mix Incorporated as recommended by the Executive Director and adopt the Executive Director's response to comments.
Second.
All those in favor say aye.
Aye.
Motion passes. Thank you.
Item number 4 is the consideration of an application by 3405 Investments, LLC for new TCEQ permit number WQ00165210001. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
Good morning. This is an application for a no discharge permit that would authorize the disposal of treated domestic wastewater from a wastewater treatment plant by land application in Williamson County. The permit would authorize the disposal of 60,000 gallons per day of treated effluent on 13.77 acres via subsurface area drip dispersal irrigation system. The commission received 4 timely hearing requests. When considering hearing requests for these type of applications, the commission first looks at effectiveness to determine whether to refer any of the hearing requests to SOA for a hearing. To be considered an affected person, the requester must explain how they will be affected by the application in a way that is not common to members of the general public. The hearing requester must also file both timely comments and a hearing request that identify their personal interest and the concerns that they have. The identified concerns must be within the commission's jurisdiction to address in the authorization. The commission received 4 timely hearing requests. Colleagues, I thought I'd begin by taking your thoughts on the hearing requests. Katerina?
I would recommend denying Mr. Held's hearing request. Raised issues that were general public. Thank you.
Commissioner Miller.
I would grant the hearing requests of Joe Brown and Ryan Elder and deny all other hearing requests, so that would be Mr. Held and Ms. Ybarra. I would deny both of theirs as failing to identify a personal interest different than the general public and they only made general comments in there.
I agree with both of you. Do we have a motion?
I move that we grant the hearing requests of Joe Brown and Ryan Eder, that we deny all remaining hearing requests, that we were, we don't do issues? I'm sorry.
Oh, I was going to say, do you guys want to discuss issues first? You can always take the motion, though, and discuss it on the other side, too, if you want to do that.
Let's finish your motion, and then we'll do a motion on issues.
or no, just do your full motion, and then you can, if there's any disagreement on the issues or any discussion on the issues, you can do that after the motion is made.
Then I would also refer the matter to SOA for a contested case hearing on the following issues: whether the draft permit complies with applicable buffer zone requirements, including those related to nuisance odors and effluent storage as set forth in 30 Texas Administrative Code, Chapters 309 and 222, whether the draft permit is protective of water quality by preventing wastewater effluent from discharging into surface waters or adversely affecting groundwater. C, whether the draft permit will be protective of the health of requesters and their families as well as animal life. And D, whether the draft permit complies with applicable monitoring requirements. And specify that the maximum duration of the hearing is 180 days from the preliminary hearing to issuance of the proposal for decision. And 5, refer the matter to the Commission's Alternative Dispute Resolution Program to run concurrently with SOA's scheduling process.
Do I have a second?
Second.
All those in favor say aye.
Aye.
Let's move back to the second part of our analysis on issues.
Oh, well, the issues were in there, so
Okay.
it looks like you've got agreement without any discussion.
Sorry.
No.
I'd say it's a Monday, but it's not a Monday. It's a Wednesday.
It feels like a
I have no
Monday.
excuse today. All right. Let's move on to 5.
Item number 5 is the consideration of an application by Vista Townhomes Austin LLC for new TCEQ permit number WQ00163550002. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
The next item is also for a Texas land application permit that would authorize the disposal of 24,000 gallons per day of treated domestic wastewater via surface irrigation on 6.5 acres of land in Williamson County. The commission received 3 timely hearing requests on this item. When considering hearing requests for these types of applications, the commission considers the same 2-step analysis as discussed in the last item. This item presents similar considerations to the previous item. I'll again ask my colleagues for their thoughts on effectiveness.
I thought that KC Tools' hearing request fails to include enough specificity to demonstrate a personal justiciable interest and thus fails to articulate how she qualifies as an affected person with an interest different from members of the general public.
I would also deny all hearing requests for this matter. With respect to Casey Toole, I found that her hearing request only raised general concerns and failed to explain how she or her property would be impacted by the proposed facility and disposal site. I'd also recommend denying the requests of City of Georgetown and Allison Almeida. The facility and the application areas are no longer in the ETJ of the city, and Ms. Almeida failed to raise any issues in her request, a procedural defect that cannot be resolved by her reply, because it doesn't allow the other parties an ability to address them.
All right. Thank you, Commissioner Miller. I agree with you both. I would deny all hearing requests. Do I have a motion?
I move that we deny all hearing requests and requests for reconsideration, that we adopt the executive director's response to comments, and that we issue TCEQ permit number WQ00163550002 to Austin Vista Townhomes LLC in the form of a draft permit.
Do I have a second?
I second.
All those in favor say aye.
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 Motion passes. Thank y'all. All right, we are on miscellaneous matters. Let's go to item number 6.
Okay, item number 6 is the consideration of the gifts and donations of $500 or more in value given to TCEQ, submitted for approval in accordance with Chapter 575 of the Texas Government Code. The Executive Director staff is here to present this item.
Good morning, Chairwoman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Yen Trin of the General Law Division, representing the Executive Director. Before you are the gifts and donations that received by the agency in the past 90 days. In accordance with Chapter 575 of the Government Code, the Executive Director has accepted these gifts and respectfully request your acknowledgement of these gifts. I'm available to answer any questions you may have.
Thank you very much. Mary, has anyone signed in on this item?
No one has signed in on number 6.
All right, Garrett?
OPIC supports approval of the resolution acknowledging acceptance of gifts and donations as presented by the Executive Director.
Thank you. Thanks, Jen. I've reviewed the gifts and donations and resolution, and I'm prepared to move forward with approval. Colleagues?
Same, thank you.
Agree.
Do I have a motion?
I move that we approve issuance of a resolution acknowledging the Executive Director's acceptance of the gifts and donations contained in the TCEQ Interoffice Memorandum to the Commissioners, filed in docket number 2025-1376-MIS.
Do I have a second?
Second.
All those in favor say aye.
Aye.
The motion passes. Thank you. All right, we'll move on to the enforcement docket, items 7 through 29.
So enforcement items 7 through 29 are up next, and the Executive Director's staff is here to present these matters.
Good morning, Chairwoman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Megan Hamilton of the Enforcement Division, and with me today are Amy Sedemeyer, also of the Enforcement Division, and Gitanjali Yadav of the Litigation Division, representing the Executive Director. Pending before you are items 7 through 29. The total assessed administrative penalties are $814,772, with $103,849 deferred, $123,895 applied towards supplemental environmental projects, and $587,028 to the general revenue. We respectfully request approval of these items and are available to answer any questions you may have.
Thank you very much. Mary, do we have anyone signed in on these items?
So on items 9, 12, and 20, we have individuals who are available for questions, but nobody's asked to affirmatively address the commission today.
Colleagues, do you have any questions on those items?
I do not.
Okay. Garrett?
OPIC reviewed each of these enforcement items, and we support adoption of all the orders presented by ED staff.
Thank you. I'd like to thank everyone in OCE for all the work that went into developing these orders. I'm prepared to move forward with adoption. Colleagues?
I move that we adopt items 7 through 29 as recommended today by the Executive Director.
Do I have a second? Second. All those in favor say aye.
Aye.
Motion passes.
Okay, item 30 is as the public comment session, but today we don't have anyone signed in to speak. So that takes us to the end of items posted for open session. The commission will be meeting in closed session in room 4222 of Building F at, I'm going to say 11:15.
Sure.
Okay, approximately 11:15 is permitted by the Open Meetings Act, including Texas Government Code Sections 551.071 and 74, to take up and consider matters pursuant to items numbered 31 through 34 as posted and noticed.
Thank you. This meeting stands in recess.
The commission met in room 4222, Building F, for closed session from 11:25 a.m. until 11:35 a.m. on item numbers 32 and 33, as posted in notice pursuant to Texas Government Code Section 551074. No action was taken. This agenda stands adjourned. The time is 11:49.